Representatives of the European Commission, the Italian and Romanian governments have achieved an extensive decision at the European Court of Justice. For many years, the lawyers of Hubert Friedel's Lyoness have argued that all marketers are independent entrepreneurs and therefore are not entitled to a refund. After hundreds of rulings in Austria, the European Court of Justice has, for the first time in case C455/21, with the decision dated June the 8th, 2023, sent a clear and international signal. During the hearing, in addition to the Chamber President himself, 3 other judges were responsible for the decision. Written statements were submitted for the formation of the judgment by representatives of Lyoness AG, the Romanian government represented by Gane and L Liţu acting as agents, the Italian government represented by G. Palmieri and assisted by G. Greco, Avvocato, dello, Stato, and the European Commission represented by A. Boitos and N. Ruiz García acting as agents. After hearing the Advocate General, the decision was issued. The judgment of the European Court of Justice, 5th Chamber, dated June 8, 2023, clarified significant questions regarding consumer protection and the interpretation of Directive 93/13/EEC. It takes a detailed look at the business practices of Lyoness, also known as Lyoness and My World, and its potential classification as a pyramid scheme. The article aims to explain the Lyoness judgment and its implications for those affected. Directive 93/13/EEC aims to protect consumers from abusive clauses in consumer contracts. It defines a consumer as a natural person acting outside their profession or business activity. A clause that has not been individually negotiated is considered abusive if it creates a significant imbalance in the rights and obligations of the parties to the contract. In the case of Lyoness, the business model, which includes cashback and network marketing, had been assessed differently in various countries, with classifications as a pyramid scheme also made. Members of the cashback and network marketing scheme were quickly introduced to other business areas and labelled as marketers, implying a form of self-employment. This case is the basis for the European Court judgment, Mechanical Engineer versus Lyoness Europe AG. The plaintiff, a mechanical engineer without commercial or professional business activity, entered into a membership contract with Lyoness Europe. This system offers members discounts and other benefits when shopping with affiliated merchants and allegedly provides passive income. He challenged several clauses of the membership contract as abusive and brought the case to court. The crucial question was, who is a consumer and what defines them as such? The core issue in this case revolves around the question of who qualifies as a consumer under the European Directive. The plaintiff argued that he was a consumer because he did not engage in commercial or professional activity within the system. Lyoness Europe, on the other hand, argued as usual that the plaintiff engaged in economic activity within the system. The European Court of Justice clarified in favour of the plaintiff. Customers of Lyoness are only not considered consumers when their relationship with Lyoness can be attributed to their general commercial or professional activity. The European Court of Justice made the following essential decisions regarding the interpretation of Directive 93/13/EEC and the definition of a consumer. The decision regarding whether the plaintiff can be considered a consumer is admissible. Directive 93/13 grants protection to all consumers regardless of whether the law of a third country applies to the contract. The court emphasised that the protection under the directive assumes that the consumer is in a weaker negotiating position compared to the trader. Whether a person is considered a consumer must be examined by the national court, considering whether the contractual relationship is outside of a commercial or professional activity. Finally, the court determined that a person does not lose their status as a consumer solely by receiving certain benefits. What does the Lyoness judgment mean for those affected? The Lyoness judgment has significant implications for those affected and strengthens the allegations brought forward. It further emphasises consumer protection, and it makes it clear that a person does not lose their status as a consumer solely by receiving benefits. This means that those affected who feel vulnerable in their relationship with Hubert Friedel's company receive significant legal support. It is important to note that the judgment also has implications for marketers' ability to reclaim their contributions. In conclusion, the Lyoness judgment is a crucial milestone in the interpretation of Directive 93/13/EEC and the definition of a consumer. It emphasises consumer protection and is likely to serve as a basis for future judgments. It also highlights the importance of those affected seeking information when faced with questions or uncertainties. Hubert Friedel's long-standing facade of success has significantly deteriorated since the announcement of his company's IPO. What he has always needed was paying consumers, that his lawyers legally classified as entrepreneurs, a practice that persisted for far too long due to a slow-moving judiciary. In our current position, being the extensive alleged criminal complaints filed with the Austrian Public Prosecutor's Office for white-collar crime and corruption, Lyoness, Gane and L marketers worldwide that wish to reclaim investments have the opportunity to join the BEEEIG class action lawsuit versus Hubert Friedel and responsible Lyoness, Gane and L group companies, and should contact BE Conflict Management for representation in the lawsuit.